Hello friends. Hello. Hello. Friends, is my audio clear? Am I visible to you? Friends, is my audio clear? It was, yes. Okay, yes. Friends, in today's Unacademy Judiciary live YouTube class, we will be discussing one of the important concepts of the Code of Civil Procedure 1908, that is arrest before judgment and attachment before judgment. Okay. First, arrest before judgment. Arrest before judgment. Friends, order 38 rules. Okay, these are rules, friends. One to four are exclusively dealing with the concept of arrest before judgment. Okay. Now let us see the concept of arrest before judgment and its consequences, etc. During this first part of this session. Okay, friends. Order 38, Rule 1. It speaks about where at any stage of the suit or other than a suit for the nature referred under section 16 clauses A to D. Therefore, friends, if you go through section 16 clause A to D, these are related to the concept of immobile property. These are related to suits related to immobile property, friends. Therefore, other than these, okay, if you go through section 16 of C.P.C, suits to be instituted where subject matter situate subject to the pecuniary or other limitations prescribed by any law, suits for recovery of immobile property with or without rent or profit, for partition of immobile property, for foreclosure, sale or redemption in the case of mortgage or charge upon the immobile property, for determining any other right to do or interest in immobile property. Except these, for the compensation for wrong to immobile property, for recovery of immobile property actually under the distraint shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Therefore, except these A to D, section 16 clauses A to D, these clauses are related to immobile properties, friends. Suit related to immobile properties. Okay. Other than these, or related to movable properties or for for compensation in case of wrongs, etc. Now, any suit is instituted at any stage of the suit, the court is satisfied by the affidavit or otherwise. Therefore, every fact in a civil case must be proved with the aid of an affidavit, friends. Now, according to 38 order 38 rule 1, at any stage of the suit, if a party files an affidavit, through that affidavit he satisfies the court that, here let us see an example, friends, an illustration. Mr. A and Mr. B. Okay. Mr. A has purchased some goods from B, or this case may be as per the illustration, as per the ingredients of section 16, compensation for wrong to immobile property, a recovery of movable property actually under the destined or attachment. For instance, for compensation of wrong to the immobile property, let us take this illustration. Compensation for wrong to the immobile property. This property belongs to Mr. A. Now this property belongs to Mr. A, friends. This property belongs to Mr. A. Now, you want to construct a house here. For that purpose, he has constructed this compound wall. Now, he has placed his gate. This is a gate. Okay. This is a compound wall, friends. He has constructed a compound wall. This is the compound wall. Okay. He is intending to construct a house within this compound wall. First, he has constructed a compound wall in order to avoid illegal encroachments of others. But Mr. B claims to be the owner of its adjacent property. Okay, he claims to be the owner of this property. Okay, here he has demolished the compound wall in this part. Okay, this is the compound wall, friends. Up to this point, this property belongs to Mr. A. Now he has demolished the compound wall. He has demolished Mr. A's compound wall. Now, by virtue of some documents, A has proved that this land up to this point belongs to Mr. A only. Okay, without the consent of Mr. A, in the absence of Mr. A, Mr. B has demolished this compound wall belongs to Mr. A. Therefore, A has instituted a suit for damages. A civil suit for damages to the immobile property. Damages related to this immobile property, that is a compound wall and this place. Now, in this case, if Mr. B intend to delay the plaintiff or to avoid the process of the court, okay, or obstruct or delay the execution of the decree that may be passed against him. These were the ultimate intentions of Mr. B, friends. Okay, his intent to delay the plaintiff, to delay with intent to delay the plaintiff to get a judgment in his favor, or to avoid any process of the court, or to obstruct or delay the execution of any decree. That may be passed against him. Here, these are the intentions of Mr. B, friends. Now, in order to delay the just claim of the plaintiff, in order to avoid the due process of the court, here the court has served a summon upon Mr. B, okay, with regard to the civil suit filed by Mr. A for damages in respect of his compound wall. Now, in spite of getting knowledge regarding institution of a suit before a civil court, okay, he has evading, he is avoiding, he is intentionally evading the due process of law. He is not taking the summons, he is not taking the notices from the honorable court. Whenever a bailiff from the court comes to his place of residence in order to serve a copy of summon or notice from the honorable court, he is cleverly avoiding that process of the court. Or if he obstructs or delay the execution of the decree that may be passed against him, he is intentionally dragging the matter. Now, under these circumstances, under these intentions, if Mr. B has absconded or left local limits of the court, local limits of the jurisdiction of the court, okay, he is about to, it shows that has absconded, he has already absconded, he has already left the local limits of the jurisdiction of the court. It says about the past tense, okay. He is about to, Mr. B is about to abscond or leave local limits of the jurisdiction of the court, okay? Local limits of the jurisdiction of the court, or it shows is about means future. Has disposed of, he has disposed of or removed from The local limits of the jurisdiction of the Honorable Court. The local limits of the jurisdiction of the court his property or any part thereof. He has disposed of his property or any part thereof. Okay, he has disposed of his property or any part thereof, or he has removed from the local. He has removed from the local limits of jurisdiction of the property, his jurisdiction of the court, his property or any part thereof. Then under these circumstances, the court may issue the warrant. The court may issue the warrant, friends. Court may issue the warrant. Under Order 38, Rule 1, friends. This is one set of fact, friends. This is one set of fact. The court may issue a warrant to arrest the defendant and to bring him before the court to show cause why he should not furnish the security for his appearance. Therefore, the court may issue the warrant to arrest the defendant and bring him before the court to show cause why he should not be arrested, why he should not furnish the security for his appearance. Therefore, in order to furnish the security, the government, the civil court may pass an order under Order 38, Rule 1, friends. This is related to the intention of, if it is the intention of the plaintiff is to delay the plaintiff, if the intention of the defendant is to delay the plaintiff, to avoid the process of the court, to obstruct or delay the execution of any decree that might be that may be passed against him, then under these circumstances, if he has absconded with these intentions, if he has absconded or left the local limits of the jurisdiction of the court, and he is about to abscond, or leave from the local limits of the jurisdiction of the Honorable Court, or he has disposed of any movable property from his property, from the limits of the jurisdiction of the court, under these circumstances, the court may issue a warrant, okay, to arrest and bring him before the court of law and to show why he should not be furnished any security. Now, the second set of circumstances, friends, where the defendant is about to leave India, he is about to leave India, okay, under the circumstances affording reasonable probability that the plaintiff will or may thereby be obstructed or delayed the execution of the decree that may be passed against the defendant in the suit. Therefore, these are the reasons, friends, these are the reasons. The ultimate intention of the defendant or Mr. B here in this case is his intention is to delay the plaintiff's just claim, to avoid any process of the court, to obstruct or delay the execution of a decree that may be passed against him, and he has absconded or left the local limits of the jurisdiction of the court, or he is about to abscond or leave the local limits of the jurisdiction of the court, or he is about to leave India, or he has disposed of or removed from the local limits of the jurisdiction of the court his property or any other thereof, any part thereof. Under those circumstances, the court may issue the warrant under Order 38, Rule 1. Okay, there is a proviso, friends. There is a proviso for this rule, Order 38, Rule 1. The proviso speaks that provided that the defendant shall not be arrested if he pays to the officer entrusted with the execution of the warrant any sum specified in the warrant as sufficient to satisfy the plaintiff's claim, and such sum shall be held in the deposit by the court until the suit is disposed of or until the further order of the court. Therefore, friends, there is a proviso. Okay. According to this one, if the defendant pays any sum specified in the warrant or the sum specified in the warrant, and that amount is sufficient, to satisfy the plaintiff's claim. Okay, then the sum shall be held in deposit by the court. Then under those circumstances, defendant, okay, shall not be arrested. Friends. You shall not be arrested. This is the provision. Here, Order 38, Rule 2 speaks about security or surety. Okay, security is the title. This is the actual title here, friends. Security. If the defendant is not in a position to deposit this amount, which can sufficient to satisfy the plaintiff's claim, then what is the remedy available to him in order to avoid the arrest from the honorable court? What is the other alternative? The other alternative is security or surety, friends. If he has no money, he is not able to pay the sum specified in the warrant. Under those circumstances, on behalf of the defendant, a third party can pay or deposit the money that is sufficient to satisfy the petitioner's claim. Then the petitioner then the defendant shall not be arrested, friends. Then the defendant shall not be arrested. It is stated under Order 38, Rule 2. Therefore, security, where the defendant fails to show such, the court, where the defendant fails to show such cause, the court shall order him either to deposit in the money, deposit in the court money or other property sufficient to answer the claim against him, or to furnish the security for his appearance at any time, when called upon while the suit is pending, and until the satisfaction of any decree that may be passed against him in the suit, or make such order as it thinks fit in regard to the sum which may have been paid by the defendant under the proviso to the last preceding rule. Therefore, friends, this surety, this amount must be sufficient to answer the claim of the plaintiff, and this okay, along with this surety, okay, this surety means the third party gives a security before the court. He acts as a surety that whenever the court directs the appearance of the defendant, he must produce the defendant. Okay, whenever there is a direction, by the honorable court for appearance of the defendant. Under those circumstances, the surety must produce the defendant before the court of law. This is the condition, friends. Okay, until pending of the suit or until satisfaction of the any decree to the plaintiff. Okay, until satisfaction of the decree that may be passed against the defendant. Okay, or the sufficient amount. This one, friends, this one, the sufficient amount. Therefore, until the satisfaction of the decree, okay, whenever the court requires his appearance, the surety must produce the defendant before the court of law. That is a second one, friends. Every suit for appearance of the defendant, every surety for the appearance of the defendant shall bind himself in default of such appearance. Therefore, surety shall bind himself friends, in default of the appearance of the defendant. Okay, the surety shall pay any sum of money which the defendant may be ordered to pay in the suit, which the defendant may be ordered to pay in the suit. Therefore, whenever the defendant fails to appear before the court, whenever the court directs his appearance, then the surety shall bind himself. The surety steps into the shoes of the defendant and he shall bind himself to pay the suit amount. He has to pay the money which is sufficient to satisfy the plaintiff's claim. Therefore, friends, the surety shall take the liability. He shall bind himself for payment of the amount which is sufficient to satisfy the plaintiff's claim. This is about Order 38 Rule 2, friends. Order 38 Rule 2. Thereafter, Order 38 Rule 3. Procedure on application by surety to be discharged. Here, discharge of surety. Order 38 Rule 3 is speaking about discharge of surety. A surety for appearance of a defendant, okay, may at any time apply to the court in which he became such surety to be discharged from the from his obligation. Therefore, may apply means he has to file an application before the honorable court, okay, to be discharged from obligation, to be discharged from his obligation. Okay, namaskar, Rajroy ji, namaskar. Okay, not visible in the screen. Okay, let me select another color. Discharge of surety it says that the surety shall apply. Here it means that he must make an application, he must file an interlocutory application to be discharged from his obligations. Therefore, on such application, once he files the interlocutory application for his discharge, the court shall summon the defendant to appear before the court of law, or if the court thinks fit, okay, the court may issue the warrant. Or the court may issue the warrant. Okay, this is the procedure, friends. Then once on the appearance of the defendant in pursuance of the summons, if the defendant appears before the court, if the defendant appears before the court, okay, in pursuance of the summon or warrant, on his voluntary surrender, okay, on he voluntarily surrenders before the court, or after servicing of a summon to him, he appeared before the court of law, or after issuing of a warrant, he appears before the court of law, or he voluntarily surrenders before the court of law, then the court shall direct the surety. Then the court shall direct the surety नमस्कार Jaimini Pandeji, namaskar. The court shall direct the surety to be discharged from his obligation. Therefore, shall call upon the defendant to find a fresh surety if he is not able to furnish the sufficient amount to satisfy the claim of the plaintiff. Therefore, this is the procedure, friends, for discharge of the surety. Here we have seen that this is the procedure order 38 rule 1 speaks about. In order to delay the plaintiff, to avoid any process of the court, to obstruct or delay the execution of any decree that may be passed against him, if the defendant has absconded or left the local limits of the jurisdiction of the court, he is about to abscond or leave the local limits of the jurisdiction of the court, or he has disposed of his property or any part thereof from the local limits of the jurisdiction of the honorable court. Here this means that it is a movable property, friends. Or he is about to leave the India. Under these circumstances, okay, on application filed by the plaintiff under order 38 rule 1, the court may issue the warrant. The court may issue a warrant, friends. The court may issue a warrant. Okay, the next step is that there is a provision, friends. If the defendant pays the sum specified in the warrant and that sum is sufficient to satisfy the plaintiff's claim, then the defendant shall not be arrested. Shall not be arrested, friends. Okay, shall not be arrested. There is an option, friends. If the defendant is not able to furnish the security, sorry, if he is not able to pay the specified amount which is sufficient to satisfy the plaintiff's claim, then he has an option. He has one more alternative. that is stated under Order 38 Rule 3, friends. He may produce the security from the third party. Here, the third party shall pay any sum of money which the defendant may be ordered to pay in the suit as per the order of the court under Order 38 Rule 1 of C.P.C. Once any third party pays such amount, then the surety or the third party who furnishes the security shall bind himself to produce the defendant whenever the court asks for his appearance. Then the surety shall bind himself. He steps into the shoes of the defendant, friends. Therefore, thereafter, Order 38 Rule 3 speaks about discharge of the surety. Okay, if the surety wants to discharge his obligation with regard to the claim in a particular suit in which he has given his surety, or he has furnished the security, under those circumstances he has to file an application for discharging him from his obligation, friends. Then therefore he has to file an interlocutory application praying the honorable court to discharge him from his obligation in the specified case. Then, after satisfying the reasons stated in his application, the court shall summon the defendant to appear before the court of law, or the court may issue a warrant to him to appear for his arrest. If the defendant appears before the court in pursuance to this summon or this warrant, or the defendant voluntarily surrenders before the honorable court, then the court shall direct the surety to be discharged from his obligation. Then the defendant steps into the shoes of the surety. Therefore, he has to seek for a fresh surety in order to avoid such order of warrant for his arrest before judgment, friends. This is about Order 38 Rule 3. I think you got the point. Okay. Royji, Raj Royji and Jaimini Pandeyji. Thereafter, Order 38 Rule 4. Okay. It speaks the procedure when the defendant fails to furnish the security or find a fresh security. Okay. Here, Order 38 Rule 1. Defendant has to pay, has to furnish or deposit sufficient money to satisfy the plaintiff's claim. The plaintiff's claim, friends. It speaks about the same. It issues the warrant. The court issues a warrant to the defendant, and bring him before the court of law to show cause why he should not furnish the security for his appearance. This is about section Order 38 Rule 1. Okay. If the defendant is not able to furnish or deposit the sufficient money to the satisfaction of the plaintiff's claim, then he may have an alternative that is stated under Order 38 Rule 3. Rule 2, sorry. It is an alternative. Okay, in case he fails to furnish the deposit, he may produce the third party's surety. Okay. Okay, these two sections are related to this one, surety, or this one. Now, Order 38 Rule 3 speaks about this one. It is interrelated with this one. Okay, if the surety was discharged from his obligation. Okay. In case if the defendant is failed to furnish the security, or if the surety is discharged and the defendant fails to furnish fresh surety, then according to order 38 rule 4, according to order 38 rule 4, where the defendant fails to comply with any order under order rule 2, order 38 rule 2 or rule 3, okay, then the court may commit him to civil prison. Then the court may commit him to civil prison. Until the decision of the suit, or where a decree is passed against the defendant until the decree has been satisfied. Therefore, if the defendant fails to furnish the security, or if the surety was discharged from his obligation, and after discharged, if the surety is discharged from his obligation, if the defendant fails to furnish a fresh surety, under those circumstances, according to order 38 rule 4, he may be committed to civil prison, friends, civil prison, provided that there is a proviso, friends. It says that no person shall be detained in prison under this rule in any case for longer period than 6 months. Okay, the minimum period is 6 weeks, friends. 6 weeks. And the maximum period is 6 months, friends. 6 months. Okay, this is the minimum and this is the maximum. Minimum 6 weeks, maximum 6 months. Okay. When the amount or value of the subject matter is, when the amount due by the defendant to the plaintiff or value of the subject matter okay is not exceeding, does not exceed, it means that it is not exceeding 50 rupees, there is no civil prison, friends. Okay, it says that provided that no person shall be detained in prison under this rule in any case for longer than a period of 6 months, nor for a longer period than 6 weeks, when the amount or value of the subject matter of the suit does not exceed 50 rupees. Therefore, okay, it must be more than 50 rupees. Under those circumstances, the minimum period of the civil prison is 6 weeks or maximum period is 6 months, friends. Provided that no person shall be detained in prison under this rule after he has complied with such order. Okay, therefore, order 38 rule 1 to rule 4 of C.P.C is dealing with arrest before judgment. Arrest before judgment, friends. Okay, this is about arrest before judgment. Friends, I think you got the point. I think you understood this concept very well. Thereafter, attachment before judgment. Okay, attachment before judgment. The remaining orders from order 38 rule 5 to rule 11, I think so. Okay, rule 13, these are related to attachment before judgment. Attachment before judgment. Now, let us see very quickly, friends. Okay. Let us complete this one very quickly. Where the defendant may be called upon to furnish a security for protection of the property. It is stated under order 38 rule 5. Okay, according to order 38 rule 5, where at any stage of the suit the court is satisfied by an affidavit or otherwise that the defendant, with intent to obstruct or delay execution of any decree that may be passed against him, obstruct or delay, these are the common words, friends, for arrest as well as attachment of the property, immobile property, he is about to dispose of whole or any part of his property. If the defendant is about to dispose of the whole or any part of his property, or any part of his property, or this is related to immobile property, friends. This is related to immobile property. This one is related to immobile property. The second one is the defendant is about to, okay, remove the whole or any part of the property. See the difference. Dispose of, remove. Dispose of is related to immobile property. Remove is related to mobile property. Okay. He is about to remove the whole or any part, his property from the local limits of the jurisdiction of the court. These are the two essential conditions, friends. The court may direct the defendant under these circumstances whenever the plaintiff files an affidavit, okay, stating that, okay, the defendant is about to dispose of the whole immobile property, or the defendant is about to remove the whole or any part of the mobile property from the local limits of the jurisdiction of the honorable court, then the court may direct the defendant within the time to be fixed by it, okay, within a fixed period of time, either to furnish the security as a particular sum of money specified in the order, to produce and place at the disposal of the court when required the said property or the value of the same or such portion thereof as may be sufficient to satisfy the decree or appear to show cause why he should not furnish the security. Therefore, the court may ask to produce the security to the value of the suit or to the value of the property. This is about Order 38, Rule 5. There is another part, friends. Okay, sub rule 2. The plaintiff shall, unless the court otherwise directs, satisfy the property required to be attached and the estimated value. Okay, Order 38, Rule 5, Clause 2. This speaks about the plaintiff shall, this is the important word, friends, shall specify the property. He has to do two things. He has to specify the property. If it is a mobile property, he has to specify the immobile property. Yes, it is located in Kadapa district, Kadapa urban sub-district, Kadapa within Kadapa municipal corporation area, within a particular locality of Kadapa, in so and so survey number. The land to an extent of 1 acre, bounded by east land of Mr. A, west land of Mr. B, north road, okay, south land of Mr. Z. Now these specifications must be mentioned by the plaintiff. Okay, the particulars, the specific particulars of the defendant must be specified by the plaintiff. It is the duty of the plaintiff to specify the particulars of the property belongs to belongs to the defendant. He is none other than the person whose property has to be attached. Therefore, he has to give the full specifications regarding the mobile property or immobile property, which may be attached before the judgment in a particular suit proceedings. And the plaintiff shall, this is also shall rule, friends, the plaintiff shall specify the estimated value of such property. Estimated value of the property, generally schedule, okay, Kadapa district, Kadapa sub-district, within Kadapa corporation, survey number, extent, okay, boundaries, or other stipulations like easementary rights, etc. Here, plaintiff's estimated value or petitioner's estimated value of the property, rupees 50 lakh, okay, etc. Generally, this shall be specified by the plaintiff in his petition. Therefore, Order 38, Rule 5, Clause 3 speaks about the court may also order direct the conditional attachment of the whole or any portion of the property so specified. Therefore, the court may pass a conditional attachment order. A conditional attachment order. Here the condition is that he has to either produce the surety. If he fails to produce the surety, the court may conditionally attach such property once the property is attached according to, okay, friends, if you go through section 46, just go through section 46. Section attachment of immobile property, removal, okay, attachment of salary, allowance, private employees. Just to go through this one. Okay, attachment of immobile property. These are related to this one. These are the related to attachment of the mobile properties or immobile properties. Section 41. Section 41 to section 57. Okay, section 41 to section 57 of CPC are dealing with the concept of attachment, friends. The concept of attachment. Therefore, these sections are related to attachment. Just go through, friends. Just go through in order to get more knowledge regarding this concept, the concept of attachment, the concept of attachment. Now, this is about Order 38, Rule 53, friends. The court may conditionally attach such property. Once the property is attached, then the plaintiff has to send a legal notice through his counsel to the concerned registering authorities to not to entertain any kind of alienations, not to entertain any kind of registrations with regard to that immobile property. Okay, this is not stipulated under order 38, friends. However, it is a general procedure followed by a civil advocate, an advocate practicing in civil side. Therefore, it is speaking about order 38 rule 5(3) is speaking about the same thing. The court may pass a conditional attachment order. Order 38 rule 5(4) is speaking about if an order of attachment is without complying with the provision of sub rule 1. This is sub rule 1. Okay, sub rule 1 says that he has to furnish the surety. He has to furnish the surety for a fixed period of time, or he has to furnish a security. Then, if an order of attachment is made without complying with the provisions of sub rule 1 of order 38 rule 5, such attachment shall be void. Therefore he has to given an opportunity to produce the security, and if he fails to produce the security within a stipulated period of time, then the court may attach the property. Friends, generally the court may issue an opportunity for the defendant, okay, for a period of 48 hours. Okay, the defendant has to submit the surety for the suit amount within 48 hours without fail. If he fails to furnish the security within 48 hours, his property shown in the interlocutory applications petition, in the schedule of the interlocutory application filed by the petitioner plaintiff, shall be attached conditionally. Okay, but friends, in order 38 rule 5 application, okay, the plaintiff files an affidavit. Along with the affidavit, he has to file a petition. In the petition, he has to specify the property and its estimated value. This property is not belongs to the plaintiff, friends. This property belongs to the defendant. Okay, this is about order 38 rule 5, friends. Order 38 rule 6. Attachment where cause not shown or security not furnished. Okay, if the defendant fails to show cause why he should not furnish the security, or if he fails to furnish the security, defendant fails to produce the security, okay, within the fixed time, then the court may order for attachment. The court may order for attachment of such property. Attachment of defendant's property. Okay. If the defendant fails to produce the security, this is the case. If the defendant produces a security, what will happen if the defendant produces the security? If the defendant produces the security, then the property specified or any portion it has been attached, okay, then the attachment may be raised or withdrawn, friends. Attachment order of the court may be withdrawn or may pass any other order as the court thinks fit and proper in the interest of justice. Thereafter, after order 7, friends, order 7, after order 6, order 7, friends, order 38, rule 7, mode of making of attachment. Mode of making of attachment. The mode of making of attachment should be, okay, in the manner provided for attachment of the property under order 21, rule 58. Therefore, as per the execution proceedings, once a decree has been passed, okay, if he dishonors the decree, okay, if he fails to obey the decree of the honorable court, under those circumstances, okay, then the party, the DHR, the decree holder, may files an execution petition before the court of law in order to get executed his decree by the court. Then the court may execute its decree. First, it attaches the property. Thereafter, it conducts the sale. After sale, the amount of sale will be reduced, or it shall be distributed to all the decree holders. Okay, this is a procedure generally followed in case of execution proceedings. Therefore, according to order 38, rule 7, as per the execution of a decree, as per the mode of execution of a decree, the attachment before judgment has to be attached. It has to be attached to the immobile property. Thereafter, order 38, rule 8, friends, adjudication of claim to the property attached before judgment. Where any claim is preferred to the property attached before judgment, such claim shall be adjudicated upon in the manner herein before provided for adjudication of the claims to the property attached in execution of a decree for payment of the money. Therefore, these are similar, friends. These are similar. Next, order 38, rule 9. Okay. Order 38, rule 9 speaks about removal of attachment. Removal of attachment. The court may remove the attachment order whenever the security is furnished. This is one option. Or the second option is that whenever the suit is dismissed, if the suit of the plaintiff is dismissed, or if the surety is furnished by the defendant, or if the suit is dismissed, then an order for attachment before judgment, okay, shall be removed, friends, shall be removed. Thereafter, order 38, rule 10 of C.P.C speaks about attachment before judgment not to affect the rights of strangers, nor barred to the decree holder for applying for sale. Therefore, it very clearly says that, okay, the third parties can file a claim petition, okay, if it is not the property of, okay, if it is not the property of the defendant, then the true owner of the property may file a claim petition. Okay, he may file uh, uh, before the court of law. He may file an application, even though he is not a party, even though he is not a party to the proceedings. Okay, or he may file an application for sale of the property under attachment in execution of a decree. Other decree holders can also file, they may go for the sale, friends. Okay, once the property is attached, the third parties can also go for the sale. Okay, they can initiate the sale proceedings. It is no bar, even though it is attached. Thereafter, Order 38, Rule 11, it speaks about property attached before judgment not to be reattached in execution of a decree. Okay, not to be reattached in execution of decree. In execution of decree, friends, once a property has been attached before judgment, okay, a property is attached before judgment, then judgment is pronounced, a decree and judgment, okay, a decree and judgment is pronounced. After judgment, EP is filed, execution petition is filed. In execution, there is no necessity to reattach the property directly. It may go for proclamation on sale, or it may go for sale. There is no necessity for reattachment of the same property in EP, in execution proceedings, not to be reattached in execution of a decree. It is stated under Order 38, Order 38, Rule 11, friends. Okay. Order 38, Rule 11, A, okay, clause sub-rule 2. This is very important, friends. An attachment made before the judgment in a suit which is dismissed for default. Okay, the suit is dismissed for default. Okay, the suit is dismissed for default. The plaintiff is failed to, okay, run his case. Therefore, the suit is dismissed for default. Okay, if the suit is dismissed for default, any attachment order, okay, an attachment order has been passed by the court. There is an attachment order, attachment before judgment. Okay, the suit is dismissed for default. Thereafter, he has filed an application for restoration of the suit. This dismissal for a default has been set aside and the suit is restored. Now, once the suit is restored, the attachment before judgment, the order of attachment before judgment cannot be revived. Cannot be revived. Therefore, this cannot be restored. Very important, friends. Okay, he has to file a fresh application under Order 38, Rule 1 for attachment before judgment afresh. Therefore, the suit can be restored even though it is dismissed for default after the dismissal for default order is set aside, but the order passed by the honorable court with regard to attachment before judgment, it cannot be revived and it cannot be restored. It is very important principle, friends. It is very, very important principle. Thereafter, order 38, rule 12 speaks about exception. Order 38, rule 13, these two are speaking about exceptions. The first one is agriculture produce not attachable before judgment, no attachment before judgment. Sorry, no attachment before judgment. Before judgment in respect of agricultural produce. Okay, agriculture produce. This is one. This is one exception. The second exception is that this is stated under rule 13, friends. It is stated under small cause court. Small cause court not to attach immobile property. It can attach to the mobile properties. Okay, nothing in this order shall deem to empower any court of small causes to make an order for attachment of immobile property. Therefore, the small causes court can attach the mobile property only. This is about attachment before judgment and arrest before judgment. Friends, I think you got all the points here. Friends, if you want to compete with thousands of aspirants and to stand out from the crowd, get Unacademy subscription today. Okay, you can get the Unacademy subscription today. Friends, you can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% of offer in Unacademy Judiciary subscription amount. Friends, the top educators of Unacademy have been conducting free live classes in Unacademy Judiciary. Okay, learners app. In these free classes, these special classes which are conducted by the top educators on every day. Okay, these free classes will cover Indian Contract Act, C.P.C, jurisprudence, Hindu law, constitutional law, criminal procedure code, all other local laws of your respective states, IPC, Evidence Act, and other laws which are prescribed in your syllabus. Coming to the specific features of or special features of these free special classes, these are interactive live classes. You can attend the live classes, you can participate in the live chat, friends. There is an option for poll for the learners. You can respond for the polls for better understanding of a topic. There is a raise for a hand, the raise your hand, friends. Plus subscribers can directly talk with the educators in the live classes and they can get the doubts resolved, friends. You will get notified for all the lessons, upcoming courses and recommendations curated for you. Therefore, you will get notifications for all these. You will get lecture notes by way of PDF. You will have also access to revisit the important topics of the recorded sessions. You can watch these classes at any time and anywhere using your electronic gadget, having internet facility. Friends, once you get the plus subscription, you will have access to get all the services of Unacademy Judiciary. You will get India's best educators. You can take the interactive live classes. You can take the live test. You can participate in the live quizzes. You will get the structured courses and PDF notes of all these files, friends. These are the special offers for Unacademy Judiciary. If you buy 12 months subscription, you will get 1 month subscription free. If you buy 18 month subscription, 2 month subscription is free. If you buy 24 month subscription, you will absolutely get 4 month subscription free, friends. This offer is ending soon. Therefore, subscribe today. Along with this, Unacademy Judiciary also conducting T20 mock test series on core subjects of APC, core subjects of judiciary, especially IPC, CRPC, CPC, and Evidence Act from Monday to Friday at 9 a.m. to 9:30 a.m. On every Friday, there will be a mixed bag series, friends. On every Saturday and Sunday at 7 p.m. to 8 p.m., there will be a detailed analysis of all these tests. Friends, the top educators of Unacademy have curated detailed batches and detailed batch courses to provide you with everything you need to crack judiciary examinations of your respective states. A batch has been started on 7th July, September 15th, 8th September, 6th October, 13th October, 27th October. This is a new batch, friends, a new batch was started on 3rd November. You can also join in any of these batches. Okay, you can continue the live classes. You'll get the access to watch the recorded sessions of each batch. Friends, the name of Aramb Unacademy Judiciary has started free test series for Rajasthan Judiciary and Haryana Judiciary services. You can take these free mock test, friends. These are the schedule. These are the dates and timings of Haryana Judiciary and Rajasthan Judiciary services. The students of or the learners of other states can also avail this great opportunity because these mock tests will cover basically core subjects, friends, IPC, CRPC, Evidence Act, Transfer of Property Act, Limitation Act, Specific Relief Act, Negotiable Instrument Act, Juvenile Justice Act, Domestic Violence Act. These are common for all the judiciary services examinations. Therefore, the students of other states can also avail this great opportunity. Friends, with the name of Rapid Revision Series for Rajasthan Judiciary and Haryana Judiciary services from 18th October 2021 onwards, Unacademy Judiciary with the aid of Karan Sanwangji, Iswani Bansalji and Faizan Khanji has been conducting rapid revision for the aspirants of judiciary services. Friends, these are the plus subscription plans and subscriptions. 1 month, 3 months, 6 months, 12 months, 18 months, and 24 months plans are available. These are the prices for various plans, friends. These are the prices for various plans. You can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% of offer in the subscription amount. Friends, Unacademy Judiciary has also started Unacademy YouTube channel. My live classes will be available exclusively on Unacademy Judiciary YouTube channel at 9 p.m. on every Tuesday and Thursday, friends. Okay, friends, apart from this, Unacademy Judiciary has also started Telegram channel. Okay, you can join in this Telegram channel. Once you join in this Telegram channel, you will get notified all updates regarding your upcoming courses, upcoming batches, okay, all the classes, etc. Okay, friends, I think you got the point. I think you got the point. I think you understood today's concept, that is attachment before judgment and arrest before judgment. This is one of the important concepts under the Code of Civil Procedure. Friends, I think you understood this concept. Okay, friends, stay tuned with Unacademy Judiciary. Let us crack it.